You're listening to a Mel and Kim Productions podcast. What happens when a lawyer and a family mediator step into a bar? Join us to find out. Dianne and Paula have real conversations about the family law process in Australia. Whether you're a part of the family law system or about to engage in the process, find out what the realities versus perceptions are. Dianne and Paula don't hold back on their individual perspectives and experiences.
We'd like to acknowledge the traditional custodians of the land from which we broadcast today and acknowledge their elders, past, present, and emerging.
Welcome to A Lawyer and a Mediator Walk Into a Bar. I'm Dianne Loveday. I'm the Principal Mediator of Bayside Mediation in Bayside area of Melbourne. And my colleague Paula Appelhans.
Hi, toss it over to me.
Toss it over. Yes.
I'm Paula Appelhans. I am an American, turned Aussie now. I'm a principal lawyer at Betts Law Company. But this show really isn't about discussing legal cases or law, or we're really here to break down I'm going to call it the realities of what it takes to go through a separation, and what it looks like to litigate a family law matter, and just some real world discussion about how to stay away from it all.
Yeah, exactly. So really offering the two perspectives, because whilst we work hand in hand and under the same umbrella of family law, our perspectives can be a little bit different.
I would say a lot different. And that's a good thing. Good thing.
Okay. I'm trying to be, nice.
I don't know why.
No, all right. Okay.
This is our podcast.
I'll ease into this. It'll be good. But yeah, the whole idea of this is for us to give our listeners a whole other perspective on how family law can work if you just look at it slightly differently.
And just be a little more familiar with it as you go into the process. Oh, yeah. We're not sugarcoating anything. We're not going to make it scary. But there are some realities. And we just thought it was a good idea to start having this conversation and have it with you, the listeners.
Yeah, knowledge is power.
Well, let's start with what the difference is between mediators and, lawyers, because they're both very important and actually critical to the process in Australia.
Absolutely, but this is a really big topic. We know that, don't we?
We'll narrow it down as we go. But
Right,
let's look at some major points then, I guess.
So my qualification to be a family dispute resolution practitioner, I've had to do a graduate diploma in family dispute resolution. There are units of law in that graduate diploma, but I'm not a member of the bar. I have a psychology degree, and to do this type of work, and we'll go into this in a little bit more detail further into the podcast, but ostensibly I'm not a lawyer, and if I'm being cheeky, I think that is my strength.
It is.
I see family law from the perspective of what's in the best interest of the family, the children, and whilst I know there's a lot of lawyers who also see it that way, their obligation to the law is different to mine.
Well, ours is more of an advocacy, let's be very honest. We're set up to be an advocacy model. So that entire aspect can create obstructions. Yeah. Whereas I think a dispute resolution aspect is about being a little more collaborative. Even though there are collaborative lawyers out there, and that's a whole different term. But the idea, especially as a lawyer, is, a client comes in and says, hey, I want you to represent me, but I want this, 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 and this. And you're like, well, these are my instructions. That's my job. Mm-hmm. However, we can best do this throughout the system. But I think in mediation, you don't have those constraints. Actually, you can't have those constraints.
Well, we're often the only people in the family law space that hear both sides of the story, other than a judge. Yeah. So,
without it being self-edited.
Yes, exactly. So when people come and sit and say to me, I want you to do blah, 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 I go, look, sorry, I'm not here to advocate for your best interest. I'm not here to advocate for the other party's best interest. I'm required to be impartial by law. Mm-hmm. But I am required to advocate for the best interests of the children of this relationship. So what do we need to do in order to ensure that their lifestyle and their well-being and their best interests are paramount in the discussions?
Well, let's have that chat, if you don't mind, guiding into how to pick because mediation is required before you
Yeah.
file in Australia.
Yep.
But what do? How do you go about it? Because you
So-
are the first step.
We are.
Really.
We are. And I suppose it would be prudent then to discuss all the various people who can actually. And I apologise because it is much more complicated than it needs to be.
Well, let's break it down and make it simple.
Yep.
There we go.
So ostensibly there are two types of people who mediate. So you have lawyers and then you have non-lawyers. And lawyers can work as family dispute resolution practitioners if they also have that same qualification.
Right.
So they have the qualification, they can then work as an FDR. So the acronym is FDRP. So, which is great, but if your lawyer is acting for you as a mediator, they cannot also act for you as a lawyer. So you have to have one or the other. You can't have a lawyer acting for you also as an FDRP.
Now, people don't really realize that's a huge distinction.
Oh, massive.
Because they think they're going through and it's like, oh, well, this one looks good and it's a lawyer. Oh, even better, because they know the law. But then they can't hire them afterwards if they have to go further. And it's just not always clear.
No, it's not clear. Often not clear. So if that point is, and you decide to use a non-lawyer FDRP, that's great. That's me. I have a psychology degree. My colleagues have law degrees, but they don't practice law. They only practice FDRP. But then you have people like barristers who also have FDRP qualifications. You have people who call themselves mediators, may have done the course but are not registered. So we're registered with the Attorney General's Department in order to do this work. So
when you're looking for someone, there are some things you want to look at. You want to look at the qualifications, and not just that they have a mediator certificate.
Absolutely.
They have to have that, but you want to see what was their background prior to.
Yeah.
What makes them a little more disposed to understanding your situation, more
Can
so.
I just bring you back to the mediator certificate, which again is one of those sort of muddy situations. So there is a mediator certificate in this country, and at the moment it's an NMAS, National Mediation, I should have written this down, association, and they're about to stretch this out to a bigger qualification. But that is purely mediation. So anybody who wants to mediate within any sphere of business life or public life or private life, you can do this 2-week course and you can have a mediator certificate. To be a family dispute resolution practitioner, you have done 6 months of study, you have done 6 months of prac. So you have to have 20 hours of supervision in order to be able to practice. And the really good FDRPs have done further study. So, for example, I have done, and I'm a really good FDRP, but I'm just saying, I have also done the Leah Cousins Introduction to Family Law, which is a standalone unit on family law and is recognised by the Victorian Law Council. So I wanted to know, I'm working in this space, I needed to understand how lawyers think, but also what are the implications of the things that I'm offering people.
And I think that's really key, because understanding the implications of how your work may affect this family or this couple, or helping them to move forward or exacerbating the problem or the challenges in what is it, conscious decoupling?
Isn't that a lovely term? Yes.
Had to throw that one in. I was waiting for a segue. But, again, your work, my work, it can be very impactful.
Oh,
and sometimes we don't always recognize that. I think when I'm dealing with other solicitors and other barristers, they just become, respondent, applicant, child A, child B.
Oh, yes. In my world, it's mum, dad, and the names of the children. Right. On my parenting plans, on any document, anything I'm writing out, you are mum, you are dad, and what are the names of your kids? Keep this focused on what this is. This is still a family. It's just not an intact family anymore. Right. So how do we work with that group to create an outcome that helps everybody move forward this
And that's the key goal, isn't it?
Yeah.
Because you can't. Because I know with a lot of clients, they end up being entrenched into their story. Let's put it that way.
Yep.
And the more you're entrenched, the more it is just much more difficult to not just move forward or move on, but to put their life back together in a way that they didn't know they had to anymore.
Yeah.
So when people talk to me about, well, I don't want to go to mediation, like, first of all, it's required. And if you go in with good faith and an open heart and an open mind, and understand that, this isn't a win-loss. It's not about getting that, one in the W column, because it does become, there are just people that once there's a separation, it's competitive. I hate to say that, but it's just, for some reason, I'm the better father, I'm the better mother. And it's like, well, you both have qualities.
Isn't it always interesting how everybody has been the primary parent?
Oh, done everything. I've done every nappy. I've done every feeding.
I got up in the middle of the night. I was always. Sorry, we digress. But that's your point. Is a very good one, and the reason why people need to do their research around their FDRP, because just being a mediator isn't enough.
No.
Just having the FDR qualification isn't enough. You really need further qualifications. You talk about what we call concrete thinking. So people come to the process and they're not prepared to move. We train and we work and we do other study to try and help people move on from that, and help people get beyond that concrete thinking and move beyond the win-loss notion and shift their views and their thinking towards a more amicable solution, no matter how dysfunctional the family is, can I say. And I don't shy away from families where there is some level of abuse or family violence. Given the statistics out there, it's really hard not to.
I was going to say more often than not.
Exactly.
That's what you've got.
Exactly. So you need a skill set. I've done a number of courses on dealing with what we call difficult personality types. Because it's important.
That's a very scientific name.
Well, we don't want to be rude.
Some big syndrome, or there should be a bigger name for that.
You think? Yeah. We're just trying to be, just keep it neutral.
See, I don't have to.
No.
Like, no.
Yeah, you get to take sides. I'm there saying, look, I'm not here to take sides, and I understand that this is, and empathy is a big part of what we do.
Yeah.
Massive part. And, I understand this has been a really difficult journey for you, and I really understand that this has been a really courageous decision to end this relationship. Now let me help you finish this job, finish this process in the most amicable way forward. Understand that the other party now becomes my issue, not yours. You don't have to negotiate with them. You don't have to, not until we come to do mediation. I'll get them to attend. I'll have a conversation with them. I will find out what their story is.
Well, let's go back here and do a quick step. And what is that process then when somebody says, okay, I need to do a mediation? They call you.
Okay, so they ring. And we have a prescribed process because we are part of the Family Law Act. So there are, no matter what service you use, the process is you have either what's called either an intake interview or a pre-mediation, and both parties have to have that. So the requirement of the FDRP is that we are completely confidential in our conversations with both clients.
Right.
So anything a client says to us once the process has been engaged is confidential, and we don't share information outside of the room.
Right.
Okay? So we don't send offers backwards and forwards. It's just...
not during this stage. I mean, during this stage, you're just trying to get an idea what the issues are.
Hearing the individual story, hearing what's brought people to our space. So once I've had the initial conversation with my party A, I then invite my party B in to attend. Now, the term is invite, all right? Mediation historically has been voluntary. It's only in recent times that it has become mandatory.
Yeah.
Unfortunately, not everybody is caught up, including lawyers, some lawyers, with the notion that it is mandatory. So my job then is to explain to my party B why this is a smarter choice, why it is relevant, providing all the legislation. So we give them a lot of information around the pre-litigation procedures and all the documentation explaining, we're the ones that issue a 60I certificate, for example, which enables people to initiate litigation. So we provide a lot of information and explain that this is a quicker, cheaper, kinder way forward. And it's always worthwhile to give it a go first, because lawyers are always there if this doesn't work. You can always then...
we pick up the ball and run.
Exactly.
I mean, but, and I know there are a lot of solicitors that, it's like, oh, you got to go do this because you got to get that certificate, and just go. And I know when I talk to my clients, it's like, give it a real go. I even had a judge at a trial a couple years back, literally as he's talking, and we had come to a consent, we'd come to an agreement between the parties, and he's like, look, this is a really solid parenting order. I'm really proud of the parties for negotiating this, and he's like, I'll tell you right now, he's like, in my view, the more you can negotiate, the more it is something that you two can continue. Whereas if I do an order, it's like, oh, I'm being told to do this. Versus, okay, we've made this agreement. I don't like every bit of it, and you're not going to like every bit of it. But at the same time, it's something you guys have freely negotiated, come to an agreement, and this is what you're going to do going forward. You guys have made that decision. You haven't abdicated that or given it up, your own autonomy to somebody else. And I think once people, and it's that I hate to say, but it's that psych aspect, it's that mental health aspect that says, you know what, you're right. But you've got to have those conversations. Yeah.
My problem is my clients don't believe me.
Because you look so untrustworthy.
Well, can I say it's often those difficult personality types that don't. But it's just because I'm not a lawyer. You come with a level of expertise and gravitas that I don't have. And there's this mistaken idea that somehow I'm just trying to churn up work. Well, no, I'm really not. I don't need to. It's
and I always, especially the first interview discussion I have with clients, and sometimes they've come to mediation first before they come to me. That's great. They've seen the process. They know that it's something in going. But at the same time, I'm like, look, my job is to try to negotiate this all the way through the process. I'm going to keep offering. I'm going to keep making offers, because that's in your best. Because, again, it does come down to money sometimes.
Oh, yeah.
I mean, okay, a lot.
Yeah.
A lot of times. The more we can negotiate and make it a done deal, you don't have to pay my daily cost to go to a hearing, or the trial prep. People don't understand, that's $25,000 is a drop of a hat. And that doesn't include the barrister fees. So, these things aren't cheap.
No,
but
I am.
Yeah. I'm not going to call you cheap. I'm going to say you're inexpensive.
By comparison.
Fair enough.
Yeah.
Fair enough. By comparison. But again, I think the psychology of it comes down to, you can duke it out in mediation just as well as you can duke it out, in litigation. And to be honest, a lot of times the mediation for me will narrow down the issues significantly. Yeah. And I'll be like, okay, you're in agreement with this. You're in agreement with that. You're in agreement. Okay, good. We got only two things to argue. Sweet. This is something that's easy. But, I mean, you cleared out the closet, so to speak. Yeah. And I can just come in with the pretty hangers and start.
Do the styling.
I can do the styling. Yeah, if anybody knows me, that's a laugh. But exactly. So, I mean, that's why I, as a solicitor here in the family law space, that's kind of why we're doing this, because I want people to understand this is legitimate, and it's a positive any way you look at it. And I don't know how many times I've had people come in and it's like, I demand this, I demand that. And it's like, okay, well, maybe you need another lawyer. Because first of all, we're going to have discussions. Demands are one thing, but we're going to have discussions because you need to make really valid, learned choices. So, but again, I think as a process, I know I have met with other solicitors and they're like, stupid mediation, because once you get into litigation, you go a lot of times back to another mediation.
Yep.
You go through the filings, you go through the first return or mention, and the next thing they're going to say is, okay, well, here's some more stuff, but, at this point, 2 months from now, we want you to see another mediator. And I'm like,
sort of taking us back to who can mediate. So we sort of touched on if there are lawyers who can who mediate, and there are people with my qualifications. It's important also to know that there are lawyers who do run mediations and who work with law firms. And being very careful here.
You're dancing. I see the tap shoes.
I'm dancing.
I see the tap shoes.
Yeah, because they tend to refer. Yeah,
It's a circular.
yeah, they
It's
refer
an
to
insular.
each other. Yeah.
Yeah.
And the challenge with lawyers sometimes who work as FDRs, they charge lawyer fees. Now, and that's fair enough too. That's
That's what they do.
yeah. And as I explain to my clients, their overheads are much greater than mine.
Yeah.
Your public liability insurance is like.
Well, yeah, it's a different class of insurance, right?
Completely. So there are reasons why lawyers charge what they charge, and I completely understand. But it brings me back to the notion that it's unnecessary, especially in the preliminary stages of a separation.
That's where I agree.
Yeah.
I mean, I understand about the billable hour, and there's a lot of talk in legal field about whether that billable hour is still a sustainable way to go. There are people who are experimenting with flat rates, but all in all, when we're talking about somebody who's charging between $400 and $600 an hour to top end.
7, 8.
Yeah, okay. Well, I wasn't going up towards the silks and all, but I mean,
No. If you've got a family law specialist,
yeah. Well, you're right. So there's a whole classifications in law that says I can go get a specialty certificate in law or business law or there's several specialties, and family law is definitely one of them. And it is, if I understand, it's like another 12 months of training and education and going back to school and at some point, enough already. But there's quite a few, who go straight into it. And like you said, I think that's the whole point here, is that there is a time and a place and a space. My clients go run the gamut of being, tradies and trying to survive, up to those with, who are middle income and higher. So, there are those who it doesn't bother them as long as they're getting what they think they need or deserve.
Yeah.
In the process. Not getting ripped off, and that sort of thing. But I mean, as far as, again, for me, going through someone like you, sending my clients to somebody that says, look, let's try to hammer out what the issues are first. And if we can get through them, great. I look, they do a parenting plan. Sometimes maybe we'll advise to do an actual parenting order, do a consent order, get that on file. We can have another discussion at a later date about these kind of distinctions. But the whole point is the resolution and the resolution process. We can, it's not going to be easy. Nobody's saying it's easy, but it can be something that is more palatable and something that gets to the resolution in some ways even more quickly.
Well, it generally does. I mean, for us, a long matter is 3 or 4 months.
Oh.
Yeah.
So if somebody walks into my door, I'm committed for at least a year.
Yeah, exactly.
I had a trial that just finished, and this poor guy, 3 years.
Yeah.
3 years to go through this. And you know what? I don't know about anybody else, but I walk the walk with them. And when it's a good day, it's a good day. When it's a bad day, it's a bad day for everybody. And 3 years is just too long, and especially when children are involved. That to me is just the height of not in the best interest.
No. And I think that's a topic that we need to talk about how it, the differences in why my process can be 3 or 4 months, whereas
a good 3 or 4 months.
Yeah,
because there is a process building.
Yeah,
whereas steps and goals.
The moment you initiate with litigation, you are committed to a good 12 months, if not more. And if you end up in front of a judge, it's about 2 years.
No, they're trying to minimize this now.
Yeah.
So the 3-year one is going to probably not be the norm anymore.
Wow.
The other cases I have going, the other matters I have going are probably, they have this designed to be done within 12 months because the court doesn't want to be clogged up either.
Yeah.
But it's clogged up trying to get through some of these things. But But yeah, we're trying to get through them much faster. I've had a registrar that looked at one matter that was before her. I think we were on our third return, directions hearing, mention, however you want to call it. And she's like, nope, we're ready for trial. Get ready for trial. We're not gonna keep going back and forth on these things. We're done. We've got the information.
Perfect.
Yeah. So that was great. I thought it was great. I was like, oh wow, oh gosh, okay. But the idea that it was, she's not going to keep entertaining, 2 to 3 months coming back to court. Do we have the documents? Do we have the right reports? She's like, nope, we got it all. We're good.
Let's do it.
Let's do this. And I was like, yeah.
And again, I think the changes in the legislation, and again, I think that's a whole topic.
That's a whole
again,
other topic.
A whole
Yeah.
other topic. But the changes in the legislation earlier this year, where the emphasis on FDR mediation was really ramped up by the court, gives them the opportunity, if more people utilise a service like mine first, it takes the pressure off the family court, so that the matters who have to go through court
Yeah. I mean,
have a better run at it.
but that's it, because we're narrowing down the
Yeah.
issues to
Yeah.
go before the court. That makes, I think, if we can get to if you guys can do, to me, because that's the hard part in many ways. There's always going to be the harder part of the matters going forward. But I really think it's coming down to let's streamline, not just streamline the process, for the sake of financial, impact to the families, because it can be very dear. But I think it's really coming down to the families just can't take the stress.
Yeah, it's emotional cost, absolutely.
It's beyond an emotional cost anymore.
So I suppose to just try and
Wrap it up.
Yeah, wrap it up. Yeah, and we apologise because we will ramble. It is just who we are. That when you're looking for somebody to mediate, what you're looking for ideally is somebody with an FDR, Family Dispute Resolution Practitioner qualification. Ideally, somebody who has also some other qualification, be it a psychology degree, a law degree, a business degree, a teacher, some other level of qualification that will complement the FDR qualification, and experience. And I know it's a bit of a cart before the horse thing, but there are ways of getting experience as an FDRP. Scarily enough, you can maintain your qualification with as little as one mediation a month. And that is really not enough to be a good
Now with all the
family.
different personality types out there.
Exactly. So it's really important to ask, how many mediations do you do a week?
How many have you done?
How many have you
Yeah.
done? And it's really important to have that conversation. So, there's a lot of people to choose from, but now hopefully our listeners are a little bit more informed about who to pick.
And again, as a solicitor, I mean, I understand everybody wants the work, but let's really think about the totality of the matter. And we've got families, we've got lives, we've got kids, and if we can do something along the line that can narrow that down, and then we do the harder part, I'm all for it.
Yeah.
Because at least at some point, if they've gone through mediation, say 8 out of the 10 matters are done, then at least that part is settled and resolved, and that has an effect on the psyche. I think in a positive way, generally. And then they come to me for the hard nuts and bolts, and that's good.
Yep.
That's good.
Yep. That's how it works.
There we
that's
go.
how it should work.
That's how it should work. And a little gin and tonic afterwards are all good. Well, thank you for listening and watching, and hope we've been a little bit of entertainment plus informative. And we will catch you on the next one.
Yes.
Thanks.